Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
Welcome to this custom-tailored deep dive. We have a really fascinating stack of legal documents in front of us today.
Yeah, we really do. It reads less like your typical dry corporate filings and much more like a modern corporate thriller.
Exactly. We're looking at an original complaint, filings from the Equal Employment Opportunity Commission, an amended complaint, and a highly detailed 2026 federal court order straight out of the Eastern District of New York.
It's an incredible paper trail.
Yeah.
And the narrative woven through these specific filings, it really captures the friction we're seeing in real time across the whole corporate landscape right now.
And the mission of our deep dive today is for you, the listener, to really decode the incredibly complex realities of modern employment law.
Right.
We're going to do that by tracking the brief, highly turbulent employment of a diversity and inclusion manager at a company called Schein, Inc.
And of course, the massive legal fallout that followed her termination.
Yes. And I want to explicitly state right at the top that Mark Carey identified this specific case for us to explore today because it serves as an excellent example of retaliation discrimination.
It really is the textbook example.
As we'll see when we map out the timeline, the court allowed the retaliation claim to continue under state, federal, and New York City laws. That makes it an absolutely critical case study for anyone navigating corporate environments today.
The stakes here are just monumental. I mean, these documents represent the real-world collision of so many contemporary workplace issues.
Oh, absolutely.
You've got the clash between remote work expectations and sudden in-person demands. You have the incredibly strict, sometimes counterintuitive legal definitions of what constitutes harassment versus what constitutes retaliation.
Which we will definitely get into.
Yeah. This case puts a magnifying glass on the vulnerable moments when an employee decides to speak up, and how a company's immediate reaction in the hours and days that follow can either protect them from liability or open them up to a devastating federal lawsuit.
Okay, let's unpack this. Let's start by looking at the plaintiff at the center of the storm, Carmen Jane.
Right.
According to the filings, Carmen Jane is a Black transgender woman. She was hired on March 7, 2022.
To be the Diversity and Inclusion, or D&I, manager for Schein.
Right. And the documents make a point to lay out the hiring conditions very clearly. Jane was hired as a 100% remote employee.
Which is a huge detail.
Huge. She states she was explicitly told during the hiring process that in-person engagement would always be optional for her.
Mm-hmm.
Furthermore, during that same hiring process, she explicitly disclosed her transgender identity to her direct supervisor.
That would be a woman named Seema Pansali.
Right, Seema Pansali, who held the title of Vice President of Employee Experience and Inclusion at the company.
What's fascinating here is the immediate tension that starts to build almost the moment she signs her offer letter.
Yeah, the ink is barely dry.
Exactly. We have a clear understanding, at least from the plaintiff's perspective, that this is a remote role. In the post-2020 corporate world, 100% remote is not just a casual perk.
No, it's a primary negotiating chip.
It is. Sometimes it's valued even more than salary by candidates. But if we fast forward just a couple of months to May 2022, that foundational agreement is put to the test.
So what happens in May?
Well, David Kochman, who is the Chief Corporate Affairs Officer at Schein, invites Jane to attend the annual National Sales Meeting.
The NSM.
Right, the NSM.
Yeah.
Taking place in Dallas, Texas in June. And Kochman tells Jane that the trip is optional.
Which completely aligns with her hiring terms.
It does. But then Seema Pansali steps in. She completely overrides Kochman's directive and tells Jane that, as her supervisor, attendance at this Dallas meeting is mandatory.
She actually frames it as a direct order.
A direct order to fly across the country for an in-person event when you were hired on the strict premise that in-person events were optional.
It's wild. And the amended complaint really dives into the power dynamic between Jane and Pansali leading up to this trip.
It paints a very tense picture.
It does. It notes that Pansali engaged in what Jane describes as excessive monitoring of her loyalty to the company.
Yeah, the filings allege that Pansali would frequently text and call Jane just to ensure she wasn't going to quit.
Or to check if she was actively looking for other jobs on LinkedIn.
Which is such an overstep.
Pansali apparently expressed this constant fear over Jane leaving, even though Jane claimed she had never indicated any intention to resign.
That kind of behavior paints a very vivid picture of the psychological pressure cooker Jane was operating in before she even packed her bags for Dallas.
Yeah, imagine that stress.
You have a supervisor who is demanding mandatory attendance, contrary to the employment agreement, while simultaneously exhibiting this anxious, hypervigilant monitoring of the employee's commitment.
It suggests a deeply insecure management style.
Absolutely. And it places a heavy, unspoken burden on the employee. Jane is not just managing her actual D&I duties. She is essentially being forced to manage her supervisor's anxieties while being pushed out of her remote work sanctuary.
It creates a dynamic where the employee feels constantly on the defensive.
Yes.
And there are also these very specific contextual details in the complaint regarding the nature of this Dallas trip.
The warnings she got.
The warnings. Before the event, Ponsali actually warned Jane that things at the national sales meeting could get a bit crazy.
Crazy. That's the word used.
Yeah. She told Jane that the sales team was filled with quirky personalities.
Code words, usually.
Right. And it wasn't just Ponsali. Another colleague pulled Jane aside and warned her that these meetings were notorious.
They compared the vibe to spring break.
Spring break at a corporate conference. They explicitly mentioned a past incident where a married woman allegedly got pregnant by someone other than her husband at the event.
Those warnings serve as a fascinating preamble to the legal claims that follow.
How so?
Well, on one hand, you could view them as colleagues, just gossiping or giving a friendly heads up about a boisterous corporate culture. We see that a lot in sales-driven organizations.
Sure. Work hard, play hard.
Exactly. But from a legal and HR perspective, especially considering Jane is the incoming diversity and inclusion manager, these are massive red flags.
Oh, massive.
The company's own leadership is essentially admitting to a culture that regularly crosses professional boundaries, and they are writing it off as just being quirky.
Yeah, brushing it under the rug before it even happens.
Right. They are knowingly sending a remote employee, a trans woman, who they know might be particularly vulnerable to harassment, into an environment they openly acknowledge is wild and unpredictable.
Think about that for a second. You listening to this right now. Have you ever been pushed to attend a mandatory fun event, a corporate retreat, or a massive sales conference that entirely clashed with the terms you agreed to when you took the job?
It happens all the time.
It really does. And have you ever been warned by your own management that the event was basically a sanctioned free-for-all?
It puts an employee in an impossible position.
Completely impossible. You want to be a team player. You want to prove yourself in a new role. But you're walking into a situation where the professional guardrails have been explicitly removed by the very people who are supposed to enforce them.
So Jane packs her bags.
She flies to Dallas for her first in-person interaction with her colleagues. Let's look at what actually happens when she arrives at the national sales meeting.
The timeline of events in Dallas is crucial for everything that follows.
Okay, let's lay it out.
The meeting kicks off on or about June 10th, 2022, with a large opening ceremony. During this ceremony, a video skit is played on a large screen for the attendees.
A video skit.
Yeah. It depicts a mother working from home during the pandemic, with her children playing restlessly in the background.
And according to Jane's complaint, this is where the first incident occurs. She alleges that a child in the video points to the screen and says, "Isn't that the woman you said was a boy?"
The context of how Jane experienced this is very important to note. She's attending her first in-person event. She's sitting in a large room. The dialogue in the video is fast.
And depending on the acoustics of the venue, it can be really difficult to hear perfectly.
Exactly. She isn't 100% sure she heard it correctly. The reaction in the room is mixed. Some people laugh. Others look confused and are whispering to each other, trying to figure out what was just said.
And Jane is just sitting there.
Deeply embarrassed. She interprets the comment as a discriminatory, transphobic joke targeting transgender individuals.
Which is entirely reasonable given what she thought she heard.
Right. She even tries to get a copy of the video after the ceremony to verify what she heard, to see if perhaps she misheard it.
But her requests are ignored.
Ignored completely.
Yeah.
She's never able to obtain a copy.
Which is such an isolating feeling. You hear something deeply offensive, the crowd reacts in a confused way, and you are left second-guessing your own reality because you can't get the receipts to prove it.
It's the classic bystander confusion mixed with an inability to verify the facts.
But she doesn't even have time to fully process that because the very next day, June 11th, the second incident happens.
Right.
Jane is staffing the diversity and inclusion booth with her colleague, a black man named Malik Silal.
At the booth.
Yes. Jane is wearing a colorful striped two-piece shorts and blazer suit. Throughout the morning, she is getting compliments on the outfit.
Mm-hmm.
An unidentified white male employee approaches the booth. He says he likes her suit. Jane makes a self-deprecating joke, saying that because of the stripes and her tall frame, she feels like she looks like a candy cane.
And this is where the interaction turns entirely inappropriate.
Yeah.
According to the complaint, the unidentified male employee looks Jane up and down, licks his lips, and says, "You sure look yummy enough to eat," in a sexually suggestive tone before walking away.
Jane freezes in disbelief. And to make matters worse, her colleague Malik, who witnessed the whole thing, just laughs.
He just laughs.
Jane is so rattled, she has to literally leave the table and retreat to her hotel room to take a break and process what just happened.
If we connect this to the bigger picture, we have to remember Jane's specific role at this company.
She is the diversity and inclusion manager.
She is literally staffing the D&I booth when she is subjected to a sexually suggestive comment.
The irony is just terrible.
It is. She recognizes immediately that these incidents, both the video skit and the comment from the male employee, don't just make her personally uncomfortable. They represent potential violations of anti-harassment and discrimination laws.
Right.
She's looking at this not just as a victim, but as the professional hired to prevent exactly this kind of behavior. She recognizes the profound legal and cultural liability these incidents represent for Henry Schein.
Put yourself in Jane's shoes for a moment. You negotiated a remote role. You were forced to travel against your will.
You were warned the culture was crazy.
Right. It's your very first time meeting your colleagues in person. You are the D&I manager, the person supposed to be championing a safe workplace.
Yeah?
And within the first 48 hours, you are subjected to a potentially transphobic joke broadcast on a massive screen and a sexually aggressive, degrading comment from a colleague right at your own booth while your coworker laughs.
That's a nightmare scenario.
What do you do? How do you handle that when you get back to your home office?
That is the pivotal question. And it brings us to the crucial sequence of events that follows her return to New York.
Okay, let's look at the timeline again.
Jane takes a few days to decide whether she should report the comment. Ultimately, she decides she absolutely must. On Thursday, June 16th, 2022, she has her regularly scheduled weekly one-on-one video call with her supervisor, Seema Bhansali.
This is the first time they have spoken since Jane got back from Dallas.
Right. And Jane decides to share everything. She tells Bhansali about the video skit with the potential transgender joke. She tells her about the yummy enough to eat comment at the booth.
And she frames it professionally, too.
She does. She specifically points out to Bhansali that these incidents are exactly why DEI training should be mandated across the company.
Yes.
She expresses how embarrassed she was and how incredibly awkward it was for this sexually suggestive comment to happen right in front of her male colleague.
The reaction from Bhansali, as detailed in the complaint, is very telling from an HR perspective.
Yeah.
Initially, Bhansali seems surprised, and oddly, she laughs.
Which is an inappropriate response right out of the gate.
Yeah. She then assures Jane that she will look into the video and the comment and find a resolution. So, on the surface, you have an acknowledgement of the complaint.
On surface.
But the complaint notes that for the rest of that video call, Bhansali seemed entirely disengaged. She was looking down toward her lap, appearing as though she was distracted by her phone.
Just completely checking out of the conversation.
Jane even sends a follow-up email after the meeting formally addressing the issues, but she hears nothing back on Friday.
Here's where it gets really interesting, and where the timeline becomes the absolute most critical piece of evidence in this entire saga.
The timeline is everything here.
Jane takes a scheduled day off on Monday, June 20. She returns to work the next day, Tuesday, June 21. She immediately receives an email from Bhansali requesting a meeting at 3:00 p.m. that same day.
When Jane logs on to that video call, she isn't just met by her supervisor. Bhansali is there, but so is the Human Resources Director, Archana Narayanan.
Always a bad sign when HR drops into a random 3 p.m. meeting.
Never a good sign. And Bhansali doesn't mince words. She immediately informs Jane that the employment relationship is not working out due to a poor fit, and that Jane is being terminated effective immediately.
Jane pushes back immediately. She points out the obvious. There had never been a single mention of performance issues.
None.
No warnings, no performance improvement plans, nothing to indicate things were not working out prior to this exact moment.
She explicitly states on the call that she feels she is being fired in direct retaliation for the complaints she shared with Bhansali the previous week.
And Bhansali's response to that accusation is just astonishing.
What does she say?
She claims the termination and the complaints are completely separate issues. But then she adds this incredible statement. She tells Jane that she didn't realize the video and the comment from the Dallas meeting were a problem for Jane, or she would have taken it more seriously.
That is wild. I mean, if a subordinate comes to you with an allegation of sexual harassment, what happens if the boss just ignores it? Doesn't the law step in there?
It absolutely does.
Jane mentions in the complaint that she brought up New York State labor law, Section 201 DARM is on the call. What exactly is that?
I am so glad you brought that up because it is a vital piece of New York employment law.
Okay.
Section 201 GRONG essentially mandates sexual harassment prevention policies and training. But practically speaking, it reinforces that supervisors and managers are mandatory reporters of sexual harassment.
So they don't have a choice.
They have zero choice. It literally does not matter what Pansali's personal interpretation of the event was.
Right.
It doesn't matter if Pansali thought the comment was just a bad joke or if she didn't think it was a big deal. The law requires her to take it seriously and report it through the proper channels immediately.
Wow.
An employer cannot hide behind a manager saying, well, I didn't think she was actually upset. The employee flagged inappropriate, sexually suggestive behavior in the workplace. That triggers a legal duty to investigate.
And Jane is pointing out that Pansali completely failed in that duty.
Exactly. At that point on the call, Narayan and Pansali backpedal slightly and say they will investigate the claims, but they hold firm that Jane's termination remains effective immediately.
We have to heavily emphasize the timeline here. Let's count the days.
Let's count them.
Jane reports the harassment on Thursday, June 16th. Friday is one business day. Monday, she is off. Tuesday, June 21 is the second business day she is in the office, and she is fired.
Just 3 business days passed between an employee engaging in a protected activity reporting harassment and her termination.
3 days.
In employment law, we talk constantly about the concept of pretext.
Right, pretext.
Pretext is essentially a fake reason given by an employer to justify an action that was actually motivated by illegal discrimination or retaliation.
So using poor fit to hide the real reason.
Exactly. When a company uses a vague, subjective reason like poor fit to fire someone, and that firing happens mere days after the employee filed a complaint, courts look at that timeline with extreme scrutiny.
Because it's too coincidental.
It is the textbook definition of suspicious timing, suggesting pretext.
So Jane is fired, and she decides to fight back. The documents show she files a charge with the EEOC and gets something called a right to sue letter. I've heard that term thrown around on the news, but what does it actually mean in practice? Is the government stepping in to fight her battle?
It is actually the opposite. Before you can file a federal lawsuit for discrimination under Title VII, you are legally required to exhaust your administrative remedies.
Okay.
That means you have to go to the Equal Employment Opportunity Commission, the EEOC, and file a formal charge.
And then they investigate.
The EEOC investigates, but they receive thousands upon thousands of these complaints. They only have the resources to take on a tiny fraction of cases themselves.
Right. They can't sue on behalf of everyone.
Precisely. If they decide not to litigate the case on your behalf, they issue a right to sue letter. It is basically the government saying, we aren't taking this case, but you have met the administrative requirements, and you are now officially cleared to file your own lawsuit in federal court.
Okay, that makes sense. So she is cleared to proceed. And she does.
She goes all in.
Jane brings a massive federal lawsuit in the Eastern District of New York against Henry Schein as a corporate entity, and individually against Seema Bhansali, David Kochman, and Archana Narayanan.
Right.
She throws the book at them, claiming discrimination based on gender and gender orientation, hostile work environment, and retaliation under Title VII of the Civil Rights Act, the New York State Human Rights Law, and the New York City Human Rights Law.
It's a very comprehensive complaint.
I also notice in the filings it mentions she initially filed this lawsuit pro se. I'm guessing that means she didn't have a massive legal team behind her.
It means she didn't have a lawyer at all initially. Pro se is a Latin term meaning for oneself.
So she did it alone.
She drafted the initial complaint, navigated the federal court filing system, and essentially took on a massive corporate entity and their highly paid. The defendants file a motion to dismiss, basically saying, Judge, even if we assume every single fact the plaintiff put in her complaint is 100% true, it still doesn't add up to a legal violation under the statutes she cited.
So they're saying, even if she's telling the truth, so what?
Exactly. Therefore, throw the case out now before we waste time and money on a trial. The judge's job at this stage isn't to decide who is telling the truth. The judge's job is to look at the plaintiff's story and say, if this is true, does the law provide a remedy?
Got it.
And Judge Merchant's ruling is a masterclass in dissecting the varying standards of different employment laws. Let's start with the Title VII claims against the individual defendants.
The judge immediately threw out the Title VII claims against Bonsali, Kochman, and Narayan as individuals. Why is that?
This comes down to pure circuit court precedent. The federal court system is divided into geographical regions called circuits. Jane's lawsuit was filed in New York, which falls under the jurisdiction of the Second Circuit Court of Appeals. The Second Circuit has firmly established through past rulings that Title VII does not provide for individual liability.
Meaning you can't sue a person.
You can sue your employer, the corporate entity, under Title VII, but you cannot sue your specific manager or the HR director personally under that specific federal statute.
Wow.
Now, Jane, acting pro se, actually argued that the court should apply the standard used down in the Fourth Circuit, which covers states like Virginia and the Carolinas.
Is the standard different down there?
It is. The Fourth Circuit does sometimes allow for individual liability for supervisors who hold significant control over employment conditions. But Judge Merchant noted she is strictly bound by Second Circuit precedent. She can't just borrow a rule from another region. So the federal claims against the individuals were thrown out right away. It really highlights the geographical lottery of employment law.
That is fascinating. Your rights literally depend on where your office is located.
Very much so.
Okay, so that knocks out the individuals under federal law. But what about the core discrimination claims against the company? The judge dismissed the discrimination claims, but the document says she dismissed them without prejudice.
Mm-hmm.
What does that mean, and how could a judge look at these facts, the forced travel, the video, the comment, the sudden firing, and say, there is no discrimination claim here?
Without prejudice means the court is tossing the claim for now, but leaving the door open.
So she can try again.
The judge is essentially saying, you didn't provide enough specific facts in this current version of the complaint to prove this claim, but I'm going to let you amend your complaint and try again. It is a procedural lifeline.
But as to why the claims were dismissed in the first place, it feels counterintuitive, doesn't it?
It does feel that way. But it perfectly illustrates the incredibly high legal bar required to prove disparate treatment discrimination under Title VII.
It's a high bar to clear.
To survive a motion to dismiss on a discrimination claim, a plaintiff must plausibly allege that the adverse action, in this case, the firing, was motivated specifically by discriminatory intent directed at their protected class.
So Jane had to show she was fired because she is a trans woman.
Yes. And the court found she didn't meet that burden.
Even with everything that happened.
The court looked at the sequence of events. Yes, she is in a protected class. Yes, she suffered an adverse action by getting fired, but the judge ruled that Jane failed to provide factual allegations directly linking the company's decision to fire her to a discriminatory animus regarding her gender identity.
The judge explicitly warned against what she called the false syllogism that plaintiffs often rely on in these cases.
A false syllogism.
How does that work in this context?
Think of it like this. Let's say I drive a red car. I get into a car crash today. Therefore, I conclude that I got into a crash because my car is red.
Which doesn't make sense.
That is a false syllogism. Two things being true doesn't mean one caused the other. The judge is saying that courts routinely reject the logic of, I am a member of a protected class. Something bad happened to me at work. Therefore, the bad thing happened because I am in that protected class.
You need something to link them.
You need connective tissue. You need facts showing the reason the employer pulled the trigger on the firing was specifically rooted in bias against the protected class.
But what about the comments at the Dallas meeting? Don't those show discriminatory intent? The video, the yummy comment?
Under the law, those are often classified as stray remarks.
Stray remarks.
To show discriminatory intent that led to a firing, the bias usually needs to come from the decision makers. The person who allegedly made the yummy enough to eat comment was an unidentified employee on the floor, not Bonsali or Narayanan, who fired her.
And the video skit was produced by someone else entirely.
Exactly. Because the offensive remarks were not attributed to the individuals who actually executed her termination, the court found they were plainly insufficient to demonstrate that the termination itself was motivated by discriminatory animus. It is a very strict reading of cause and effect.
That is a tough pill to swallow. So what about the hostile work environment claim? If those remarks didn't prove she was fired for being trans, surely they prove the environment was hostile.
Again, we run into a notoriously high legal standard. To prove a hostile work environment under Title VII, a plaintiff must show that the workplace is permeated with discriminatory intimidation, ridicule, and insult that is sufficiently severe or pervasive to alter the conditions of the victim's employment.
Severe or pervasive.
Those are the key words. The court looked at Jane's situation. She was employed for about 3 months, entirely remote except for this one trip to Dallas.
Right.
The complaint relies on 2 isolated incidents during that specific trip. While the court undoubtedly recognized those incidents as offensive and inappropriate, legally, they are considered episodic.
Because it wasn't happening every day.
2 remarks over a 3-month period do not meet the legal threshold of a workplace permeated with severe and pervasive hostility. The law doesn't guarantee a polite workplace. It only protects against severe or continuous harassment. So, the hostile work environment claim was also dismissed.
So what does this all mean? Did the defendants just get the entire case thrown out? Did Henry Schein and these executives just walk away entirely free and clear after firing her 3 days after a complaint?
Not even close. And this is the vital pivot point of the entire case. While the court dismantled the discrimination and hostile work environment claims based on those strict legal definitions, Judge Merchant allowed the retaliation claims to survive.
Okay, this is what Mark Carey pointed out.
Yes. She ruled that Jane plausibly alleged retaliation under Title VII against the corporate entity and, crucially, under the New York State and New York City human rights laws against all the defendants, including the individuals.
This is massive. The court essentially said, we aren't convinced you were fired because you're trans, and we aren't convinced the environment was legally hostile enough under the statute, but we absolutely see enough evidence that you were fired because you complained about it.
You hit the nail on the head. Retaliation is an entirely different beast in the eyes of the court. And frankly, it is a much easier trap for employers to fall into.
It seems like it.
It is very often a much more successful path for plaintiffs than the underlying discrimination claims. The brilliant thing about a retaliation claim is that you do not have to prove that the conduct you reported actually met the legal definition of discrimination or a hostile work environment.
You just have to prove you were punished for recording it.
Exactly. You only have to prove 2 main things. First, that you engaged in a protected activity. And second, that there is a causal connection between that activity and you being punished.
Let's break down those elements, starting with the protected activity. In the documents, the defendants actually tried to argue that because Jane was the diversity and inclusion manager, bringing up these issues was just her doing her normal job, and therefore it shouldn't count as a protected activity. They argued there was no basis for Ponsali to receive her comments as a formal discrimination complaint from a victim.
It was a bold argument by the defense, trying to use her title against her, but the court completely rejected it.
Good.
The judge noted that an employee whose job it is to report discrimination can still engage in protected activity if they are critical of the employer's discriminatory practices or if they express personal harm.
Which Jane did.
Jane didn't just submit a sterile third-party HR report about a violation she witnessed happening to someone else. She told her boss that she was the target of a sexually leaning comment. She told her boss that she was deeply embarrassed by a potentially transphobic video.
She had it personal.
She articulated the substance of her complaint in a way that any reasonable employer would understand. She was opposing unlawful discrimination directed at herself. Therefore, she was legally engaging in a protected activity.
And then we get to the second element, the causal connection. How do you prove you were fired because of that protected activity?
The judge pointed her finger squarely at the timeline.
The 3 days.
We go back to those 3 business days.
Yeah.
Firing someone 3 business days after they make a complaint of sexual harassment is textbook indirect evidence of a retaliatory motive.
It's just too glaring.
The timing was simply too close to ignore. It creates a highly plausible inference that the poor fit excuse was just pretext designed to cover up a retaliatory firing.
So that's all they needed.
The temporal proximity is all the connective tissue the court needs at this stage to let the case proceed to discovery.
Hold on, I'm looking at the timeline here and something isn't adding up. A few minutes ago, you mentioned the judge threw out the claims against the individuals Hansali, Kochman, Narayanan, because federal law doesn't allow individual liability.
Yeah,
right.
But now they're back on the hook for retaliation. How does that work?
This raises an important question, and it highlights the crucial difference between federal and state law.
Okay.
Under federal Title VII, individual managers cannot be sued, which is why they were dismissed from those specific claims. However, New York State and New York City human rights laws operate differently.
In a broader way,
In fact, the New York City human rights law is famously broader and more plaintiff-friendly than federal law. Under those local laws, individuals can be held personally liable if they aided and abetted the unlawful, discriminatory, or retaliatory acts.
Aiding and abetting, that sounds like criminal law. How did the court apply that concept to the corporate executives here?
The court looked at the specific actions of each executive leading up to the termination. For Seema Bhansali, the court found it plausible that she actively participated by providing the retaliatory intent.
Because she was the one in the meetings. She was the one who heard the complaint on June 16th. She was the one who called the termination meeting on June 21. And she was the one who delivered the news. She didn't just passively observe the retaliation, she allegedly drove the action.
And what about Narayan, the HR director, and Kaufman, the executive who invited her to Dallas in the first place?
Their involvement is equally critical to the aiding and abetting theory. The court noted allegations that Narayan and Kaufman approved the termination without consulting internal HR policies or conducting an investigation into Jane's complaints.
Bypassing their own rules?
This is massive. When executives, especially HR directors, bypass their own established procedures to fast-track a termination immediately after an employee raises a harassment complaint, the court views that deviation from protocol as glaring evidence of pretext.
Because if it was a routine firing, they would have followed the routine.
They weren't just following orders or doing paperwork. They were allegedly wielding their authority to rubber stamp a retaliatory firing without doing the due diligence their own manuals require. Therefore, they can be held individually liable under the aiding and abetting theory of the New York laws.
This is the massive takeaway for you, the listener. If there is one thing you remember from this deep dive, it is this. Retaliation claims often have much sharper teeth than the initial discrimination claims.
Absolutely.
The act of reporting a genuine concern and how the company handles that report in the immediate aftermath creates a highly protected legal bubble around the employee. A company might successfully argue in court that an inappropriate comment didn't meet the high bar of creating a hostile work environment. Right. But if they fire the person who reported that comment a week later, they are walking straight into a buzzsaw of retaliation liability. The cover-up or the punishment for speaking up is almost always easier to prove than the initial offense.
That is the central lesson here. This entire case underscores the absolutely vital importance of strict adherence to HR procedures.
You can't just wing it.
When a complaint is made, companies must pause. They must investigate. They must follow their own rule books to the letter, regardless of how inconvenient it is or what they personally believe about the severity of the complaint.
Even if the manager thinks it's no big deal.
When leaders act impulsively, when they let annoyance, insecurity, or a desire to just make the problem go away override procedural safeguards, especially within days of an employee raising a flag, they open the corporate entity, and potentially themselves personally, up to massive legal exposure.
Let's quickly recap the incredible journey we've mapped out today. We started with a disputed remote work agreement for a newly hired diversity and inclusion manager, exploring the friction between written contracts and demanding corporate cultures. We traveled to a chaotic corporate retreat in Dallas, where we witnessed two deeply uncomfortable incidents involving a potentially transphobic video and a blatantly suggestive sexual comment at a company booth.
And we watched the plaintiff report these incidents to her boss,
expecting support, only to be hastily terminated 3 business days later under the vague guise of a poor fit. We then saw how a federal judge meticulously applied the law, showing how the incredibly high bars for proving discriminatory intent and pervasive hostility knocked out the initial claims.
But crucially, we saw how the undeniable, glaring timeline of retaliation kept the lawsuit alive,
allowing the plaintiff to pursue justice against both the corporate giant and the individual executives under state and city laws.
It is a complex web of liability, but it shows how the law attempts to balance the realities of the workplace. It doesn't police every bad joke, but it fiercely protects the right of employees to complain about them without losing their livelihoods.
I want to leave you, the listener, with one final provocative thought to mull over. We have spent this deep dive talking very technically about the legal mechanics of this case, the statutes, the precedents, the motions to dismiss, the timelines. But I want you to step back and think about the human element, the chilling effect this kind of corporate behavior has on the unspoken culture of a company. Think about the message this sends to the rest of the workforce.
It's a loud message.
If the diversity and inclusion manager, the very person specifically hired and paid to champion these exact issues, the person whose literal job description is to make the workplace safer and more equitable, if that person is fired 3 days after reporting a problem, what message does that send to everyone else?
It's devastating.
What does that say to the entry-level employee sitting in their cubicle or logging in from home who witnesses harassment? They are going to look at what happened to the D&I manager, the supposed protected authority on the subject, and wonder, if they couldn't speak up without losing their job, how could I possibly survive saying something?
It creates a culture of silence.
And a culture of silence is exactly where toxicity thrives. Thank you so much for joining us on this deep dive. Keep examining the world around you, keep looking closely at the structures you work within, and keep asking the hard questions in your own environments.
Hey, it's Mark, and thank you for listening to this episode of the Employee Survival Guide. If you'd like to be interviewed for our podcast and share your story about what you're going through at work, and do so anonymously, please send me an email at mcarey@capclaw.com. And also, if you like this podcast episode and others like it, please leave us a review. It really does help others find this podcast. So leave a review on Apple or Spotify or wherever you listen to this podcast. Thank you very much, and glad to be of service to you.